Hey everyone, Brandon here from Intrastate. If you've been in trucking for any length of time, you've probably encountered lots of so-called facts about DOT compliance. Some of them might even seem like common knowledge. Of course, just because something is widely believed doesn't make it true. Today we're going to bust 5 of the most common DOT compliance myths that could be putting you or your business at risk. So stay tuned and do us a favor by clicking the like and subscribe buttons below. All right, the first DOT compliance myth we'll tackle is a big one. If my driver has a CDL, they're automatically qualified to drive a commercial vehicle. Unfortunately, we hear this all too often from fleets that just want to get their trucks moving. But it's just not true, and it will inevitably run you into big trouble. Holding a valid CDL is certainly a requirement for drivers to operate certain types of vehicles, but it's only one piece of the puzzle when it comes to driver qualification. The FMCSA has strict rules about what makes a driver fully qualified, and it goes beyond just holding the right license. For example, drivers need to complete a DOT application, present you a copy of their medical card, fleets have to contact the driver's past employers and check their driving records, just to name a few things. In short, if you're just checking for a CDL and calling it good, you could be setting yourself up for violations, substantial fines, and heightened exposure if your driver gets into an accident. So make sure you've checked all the driver qualification boxes before putting someone behind the wheel of a commercial vehicle. All right, the next myth is probably one of the most pervasive ones, and it's that personal conveyance status can be used to avoid hours of service violations when a driver runs out of hours. A lot of drivers and even some fleet managers think of personal conveyance as a loophole in the hours of service rules. They assume that if they're running out of hours, they can just switch over to personal conveyance status and keep driving. But that's not how it works. As we've discussed before in several videos, personal conveyance is strictly for personal, non-business related travel. That means a driver can, for example, use their truck in off-duty personal conveyance status to go to and from a truck stop in a nearby restaurant or entertainment venue, so long as they have been completely relieved of work responsibilities. But they can't use personal conveyance to stretch their available drive time, find parking after running out of hours on the road, or reposition their truck closer to their next pickup point. FMCSA and state law enforcement have been cracking down on this over the past several years, and log falsification, stemming from personal conveyance misuse, has become one of the most common violations noted in roadside inspections and DOT audits. It's a huge problem for many fleets, and it's leading to severe consequences, including fleet-wide out-of-service orders. So if you're not sure whether a certain situation qualifies, it's always best to double-check the FMCSA's guidance on proper PC use. All right, the next DOT compliance myth is another popular one, and it's that if you're operating only in intrastate commerce, you are relieved from complying with the majority or all of these safety regulations. As a preliminary matter, the distinction between interstate and intrastate commerce is not as intuitive as it may seem at first blush. As we discussed in another video, drivers who never physically cross state lines may still be engaged in interstate commerce and thus subject to the federal safety rules depending on the nature of their freight. Putting that issue to the side, even if you're engaged exclusively in intrastate commerce, you're not necessarily relieved of all compliance obligations. For one, certain portions of the federal rules apply to both interstate and intrastate commerce, namely the CDL and drug and alcohol testing provisions. So if you're a fleet whose drivers operate commercial vehicles that require a CDL, those that weigh more than 26,000 pounds, then you're generally subject to the FMCSA's drug and alcohol testing rules, just like an interstate fleet. Second, even if your fleet only operates in intrastate commerce, it's possible that the state in which you operate has adopted the majority of the federal safety rules and made them applicable to intrastate operations. Indeed, every state in the country, as a condition to receiving federal funds under the MCSAP program, have agreed to adopt and enforce the vast majority of the federal rules, even for intrastate commerce within their borders. That said, the states are afforded some leeway to modify those regulations, including changing their applicability. However, the point here is that intrastate-only fleets need to understand that they may be subject to their state's adoption of the federal rules, so they need to do some research to determine whether those rules apply. All right, myth number 4. Only big trucking companies are in the FMCSA's or plaintiffs' bar's crosshairs. There's this idea that if you're a small carrier, you can fly under the radar and avoid DOT audits or substantial highway accident exposure. False. For one, the FMCSA prioritizes carriers for enforcement based primarily on their safety measurement system scores, which are influenced by violations from roadside inspections. This way, the agency ensures that it focuses its resources on the carriers who seem to have the biggest issues with compliance. A carrier's size typically does not influence whether the FMCSA will conduct an audit. Indeed, most of the audits the FMCSA conducts nowadays are fleets of fewer than 50 trucks. In addition, just because you're a small fleet doesn't necessarily mean you're immune from highway accident litigation. The fact is most small fleets are required to carry a certain level of commercial auto liability insurance, $750,000 for example, that in itself makes you a target of the plaintiff's bar following a highway accident. Beyond that, if you have any assets whatsoever, trucks, trailers, real estate, those will also likely be up for grabs in the event a judgment is rendered against you that exceeds your insurance policy limits. In sum, the size of your fleet matters very little in terms of your exposure stemming from non-compliance. Okay, last but definitely not least, let's talk about smaller commercial vehicles. A lot of folks think that if their truck weighs less than 26,001 pounds, DOT regulations don't apply to them at all. While a few federal regulations, namely the CDL and drug and alcohol testing requirements, apply only to larger commercial vehicles, the vast majority of the federal rules apply to smaller vehicles, those that weigh more than 10,000 pounds, operated in interstate commerce. If your vehicle or combination weighs more than 10,000 pounds, which is not that hard to surpass, and is used in interstate commerce, you are generally subject to requirements like driver qualification, hours of service, vehicle maintenance, and DOT registration. That said, as I mentioned previously, if you are engaged exclusively in intrastate commerce, there's a possibility that your state's safety regulations apply only to larger vehicles. Texas, for example, only regulates vehicles that weigh more than 26,000 pounds. But again, it's important that you understand how the states in which you operate have adopted and enforced their safety regulations. All right, there you have it, 5 of the biggest DOT compliance myths busted. These are the kinds of misunderstandings that can cost drivers and trucking companies big time. So it's critical to do a little research and ensure you understand the rules under which you operate. For even more in-depth information about these types of regulatory topics, be sure to check out our innovative online compliance courses for safety managers and for drivers over at trucksafeacademy.com. Also, if you're looking for an easier way to access and understand the federal motor carrier safety regulations, check out eRegs, the first app-based digital version of the regulations, over at eregs.app. Lastly, be sure to subscribe to our newsletter at trucksafecademy.com/subscribe and follow us on our various social media pages for the latest highway transportation news and analysis. Thanks for watching.